Good evening, everyone. We warmly welcome you to this legal discussion on murder, a part of the Phase 3 of Law is Light of the Pro Bono Committee of the Law Students Association, Sri Lanka. We are honored to have with us today Mr. Saliya Peris, the President of the Bar Association of Sri Lanka, a Presidential Counsel, former Commissioner of the Human Rights Commission of Sri Lanka, former Chairman of the Office on Missing Persons, the Chairman of the CfPS Law School, and an eminent and well-experienced practicing lawyer in the fields of criminal law, public law, and fundamental rights law. We are expecting to discuss the questions received by us from the public in this discussion themed murder. As we are streaming live on Facebook, you can send your questions to us and they will be answered by our speakers at the end of this session.
Let's move on to the first question, which is the offense of murder is often understood by society as killing that results in a dead body. How will a person face punishment even without there being a dead body for an offense of murder?
I'm sorry, I didn't get your question.
Am I audible?
No. Yeah, go on.
Yeah, so the offense of murder is often understood by society as killing that results with a dead body. How will a person face punishment even without there being a dead body for an offense of murder?
Well, there can be instances where even if there is no dead body, if there is evidence that the person, that the victim was killed, and then the victim was killed, there have been instances where even if the dead body is not found, that a murder charge could be pursued. But then there would have to be clear evidence that the person has, that the victim has died. There would have to be that clear evidence. But in very rare cases, this would be possible.
And what about having an intention to commit murder? How is a person who has an intention to commit murder liable?
Well, intention is one of the ingredients of murder. So that is in fact the first ingredient. So you see, we have to understand that in law, not every killing is murder. Not every death results in murder is a legal term. So murder, for instance, a person might die as a result of a rash and negligent act. So someone drinks and drives and goes on the road. Someone is killed in an accident. That is not murder. That is chargeable under Section 298 of the Penal Code, causing death either negligently or by an act of rashness. Then you have willful killing of a human being. Even that is twofold. One might be unlawful killing of a human being is called culpable homicide. Now, culpable homicide becomes murder in certain instances, and one of those instances is if it is done with the intention of causing death. I would just highlight the Penal Code provision where it said culpable homicide. I think it just for very briefly, whoever causes death by doing an act with the intention of causing death, or with the intention of causing bodily injury, as is likely to cause death, or with the knowledge that he is likely by such act to cause death, commits the offense of culpable homicide. So basically, if a person kills another person with the intention of causing death, with the intention of causing a bodily injury which is likely to cause death, or even with the knowledge that he is likely by that act to cause death, he commits culpable homicide, not culpable homicide. Then culpable homicide becomes murder if the act by which death is caused is done with the intention of causing death. So you do a particular act which causes the death, and that is done with the intention of causing death, that is murder. So for instance, you take a gun. If a person takes a gun, shoots it point blank at the victim, that is an act by which death is caused, and there is no question that the intention is to cause death. Right? So that is one intention. But there is another one. If it is said the second limb of murder is, I'll go to the third limb first. If it is done with the intention of causing bodily injury to any person, and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. That is, your intention might not be to kill, but your intention is to cause a particular bodily injury which is sufficient in the ordinary course of nature to cause death. That means without treatment, without treatment, if a person is left in the ordinary course of nature, he would die. So if you commit a bodily injury where without medical intervention the person would in any way die, even that is murder. So one is your intention is to cause the death. Another is your intention might not be to cause death, but to cause a bodily injury which is sufficient in the ordinary course of nature to cause death. That is also murder. So for instance, man comes with a sword and he inflicts bodily injuries on a person. Now, one might say, well, he didn't intend to cause the death, but the bodily injuries which he causes is enough to cause the death of the person, right? So if the doctor will come and say these injuries are sufficient in the ordinary course of nature to cause death, then also it becomes murder. Then there is another aspect, that is what we call the second limb of murder. If it is done with the intention of causing such bodily injury as the offender knows to be likely to cause death of the person to whom the harm is caused. This is where you do it if it is done with the intention of causing bodily injury as the offender knows to be likely to cause the death of the person. So your intention is only to cause bodily injury. But when you cause bodily injury to that particular person, you know that person is likely to die. So we take, for instance, we say there is a person who has some ailment. We will say he has some. We say he's just after a heart attack. Now the person, the perpetrator, knows he has just come out of hospital after a heart attack. Knowing that, he goes and assaults him severely. Right? He assaults him severely, and he knows that those in itself might cause the death of that particular person. Or we say person has a particular. I think there is case law where a person had the injury was he had a particular organ failure, and the injury was aimed. I think it was at the spleen, if I'm correct. And there, as a result of that person dies. So if you know a particular person has a particular ailment, and knowing that you go and cause him such injury, where it is likely that his death will occur, that is also murder. So when you ask about intention is one of, so it's not only intention to cause death, intention even to cause a bodily injury which is sufficient in the ordinary course of nature to cause the death would also come to the offense of murder.
Thank you, sir. So what are the punishment enforced or implemented in Sri Lanka on someone who committed murder?
So if a person is found guilty of the offense of murder per se, then the punishment is the death sentence. And there is no other, at least the courts impose a sentence of death. The practical implementation from the last time, 1976, over the last 45 years, Sri Lanka has not carried out the death sentence. I prefer to say Sri Lanka has not judicially executed any person during the last 45 years. But in courts, the sentence of death is passed. And so that is if it's for the offense of murder. But if it is for the offense of culpable homicide not amounting to murder, that is, you have caused the death of a person, you have willfully caused the death of the person, but for certain reasons it does not amount to murder. It belongs to that lesser category of what we say culpable homicide, but not amounting to murder. Culpable homicide not amounting to murder. There the punishment is different.
What is the procedure under law when the accused of murder is arrested, sir?
Well, if a person is arrested for murder, really we say if he's suspected of murder, he's thereafter he'll be produced in court by the investigating officers, the police. If he produced under section 200 on suspicion of murder, he has to be remanded into custody. He cannot be given bail by the magistrate's court. He can be given bail only by the high court.
So if a third person destroys evidence, say if a friend had committed murder, and if they destroy evidence, will that person who destroyed the evidence be held liable for a crime? Does it amount to a crime?
It amounts to a crime. If you destroy evidence, there are sections in the penal code, you are obstructing justice, and there are sections in the penal code which would make it a criminal offense. So you suppress the evidence, or you destroy evidence which the law enforcement would otherwise have got. That would be a crime. So even for instance, disposal of a dead body illegally in itself is also a crime.
Okay, sir. So when a group or a bunch of people plan to commit murder, will all of them be liable for the offense of murder?
Yeah,
what if everyone who did not commit the murder, but just they were present at the situation?
Well, there are two things. One is if you plan to commit a murder, if two or more people plan to commit murder, that would be conspiracy to murder. So those people who are involved in the planning can be charged under section 113B of the penal code, read with 296. And they can be charged for conspiracy to murder. Someone who assists in a murder, who aids or abets in a murder, that includes conspiracy, assisting, or instigation. If death occurs, they can be impose the same punishment. They'll be charged under section 102 for abetment, read with 296 for abetment to murder. Then the third aspect is two or more people go to commit a murder, but one person actually commits it. The other is there. The other is there. Then, if they are acting with a common intention, then all those who take part would be liable. But so for instance, a crowd of people go away. So I'll give you this example. We say at a big match, there is a crowd of people who are drunk, or they get into a fight. They get into a fight with a person, and so they are all fighting that person. While they are fighting, one person pulls out a knife and stabs, and a person dies. Now, all the people were in the crowd which were fighting, but they might not have shared the intention of causing the death of that person. Others, their intention may have been a lesser intention to assault, intention to voluntarily cause hurt, voluntarily cause grievous hurt. But the man who pulls out the knife and stabs will be liable for murder, but the others would not be liable for murder. They would be liable only for what they did. But if we say there are a gang of robbers who go to a bank, and they overpower the security guard, and in that process, one person stabs. So when you go with the intention of overpowering the security, then there is a possibility that they all share a common intention. But then it is something which has to be looked at. The evidence has to be looked at, and the court has to be satisfied that every person shared a common what is called common murderous intention. So everyone who shares a common murderous intention becomes liable. So we say 3 people go into a house to attack. They break into the house, drag out the person. One kills. One takes a knife or a sword and attacks. But the others have, there is what is called a participatory presence. If there is a participatory presence, and there is a common, then that might be evidence of common murderous intention. But again, these depend on facts. Sometimes there might be, a person might be a mere bystander. So there is a commotion. You come rushing in. You don't share the intention with the others. Then, so it all, everything depends on the facts and circumstances of the case. There is one particular case. It's in 1976. 3 brothers were involved in a killing. One brother held the person. The other brother, I think this is I can't remember the name of the case. I think it was Basalamuni Richard.
Yes.
And it was a court of appeal. Court of appeal, as it then was the highest court. Then the one brother killed, the other held him. The third brother turned away a witness. A witness came into the forest or something, and he drove him away, frightened him away. There, the court held that the third brother was also had a participatory presence, and they found him guilty of murder. Then I must add one more thing.
Yes.
That is in the case of an unlawful assembly. That is, if there are 5 or more people who are involved in unlawful assembly, as in section 140 of the penal code. If you read down section 140, you assemble 5 or more people, and with a particular common object. You go with a common object. Then all those people who are part of that unlawful assembly, if some act is done in pursuance of a common object, of the common object, all the people become liable. So we say if a gang of 5 people go into a house, the common object is to cause assault, is to assault a person. But in the course of that, they go armed and so on, and all those in that unlawful assembly know that it is likely that it can result in the death of a person. Then they all become liable. So but that is under section 146 of the penal code, read with the murder section. That is called a common object. But for that, the unlawful assembly has to have 5 or more people. So in Duminda Silva's case, Duminda Silva was found guilty on the basis of that he was part of what was referred to as a moving unlawful assembly.
Okay, sir. So Seenath is yeah, there. So injury and grievous hurt. So are they same as murder? What is the difference?
Well, no, there is a difference, because between injury and grievous hurt and murder, the difference is, of course, the end result. The end result is obviously in murder, person dies. In grievous hurt, it is one of those set out in under section 311 of the penal code. If it is grievous hurt, then what is called, we don't call it injury. It is called voluntarily causing hurt. Is a lesser offense which is described in section 310 of the penal code. So even if you cause pain or so on, it can become hurt. But if it to become grievous hurt, it has to become within one of those limbs described in section 311. So, for example, a fracture, a permanent injury to the sight, to hearing. So those become grievous hurt.
Okay, sir. So the next question is, when there is a threat to your body or your property, then acting in self-defense. So will this the final result might be like a killing? Then will this be murder? What is the
Well, it all depends. Now you know that the right of private defense extends to the causing death. In exercise of your private defense, you can cause death, but only there are limitations to the right of private defense. So if you, for instance, if you have time to go to the authorities, then you can't exercise your right of private defense. Then you must go to the authorities. You can't lie in wait for the perpetrator to come and then attack him. Similarly, you can't cause more harm. You cannot cause more harm than is necessary. Right? So only to the extent that what is needed to defend yourself. So sometimes people in the course of exercising their private defense, they might they might exceed that the right of private defense. So there is, if you exceed the right of private defense, it is not murder, but it becomes culpable homicide, not amounting to murder. So there is a the penal code, in fact, recognizes that. They say that I will just read out that section. Culpable homicide, this is exception 2, is not murder if the offender in the exercise in good faith of the right of private defense of person or property exceeds the power given to him by law. So that is where you can exercise your private defense, you can cause death, but you exceed that right and causes the death of the person against whom exercising the right of defense without premeditation and without any intention of doing more harm than is necessary. Then in that case, that becomes culpable homicide, not amounting to murder. So basically, in a case of exercising your right of private defense, you can exercise that right up to causing of death of a person, right of defense of person or property. But there are limitations. You cannot, if you have time to go to the authorities, if you can do lesser harm, then if you exceed that, it would be still an offense, but it would be a lesser offense called culpable homicide, not amounting to murder.
So what are the steps can a witness to a murder take? If somebody is witnessing a murder taking place, what steps can they take?
Well, if you are a witness to a murder, you will have, of course, it is, I can't say you have to. You can go to the police and make a statement. Probably the police will come to you and ask you to make a statement. I think you have a duty towards the community if you witness a murder, and if you can identify what happened, then to inform the authorities of the identification. Of course, unlike for example, in the Prevention of Terrorism Act, you have if you fail to give information, you are criminally liable. Under the penal code, there is no section of failure to give information. But if you are a witness to a murder, it is your duty as a civic conscious citizen to inform the authorities.
How does the legal framework protect an eyewitness for murder?
Well, we have the Witness and Victim Protection Act, and that sets out a whole heap of rights which victims and witnesses have. And if anyone interferes with you, you are entitled to certain degrees of protection. There you have the Witness and Victim Protection Authority. You have the Witness and Victim Protection Division in the police, and you can inform if there is a threat to you. You can seek assistance from the police or from the authorities. And there is a wide range of powers which the Witness and Victim Protection Authority has to protect witnesses.
Okay, sir. So can we explain the terms injury and grievous hurt to the general public? Because some may not understand the difference. They may think it's the same thing.
Yeah, well, yeah, I think this question was asked earlier. we have to, if you go to section 310 of the Penal Code, section 310 says, whoever causes bodily pain, disease, or infirmity to any person is said to cause hurt. So if you cause bodily pain, if your act causes a disease or infirmity to any person is said to cause hurt. Then there are certain hurt becomes grievous hurt if they are under section 311. So there are many links, but for example, permanent privation or impairment of the sight of the eye. You cause injury to a person which causes permanent loss of sight or impairment of sight. If a limb or a joint is cut off, destruction or permanent impairment of the powers of any member of or joint. So we say you slash a person with a sword. If it's just a cut, it's hurt. But if there is a permanent impairment of the powers, we say as a result of the slashing of the sword, the person can no longer, his arm is paralyzed for life. That would be grievous. So disfiguration of the head or face. So you know that there are cases relating to throwing of acid, which causes a permanent disfiguration. That is grievous. A cut or fracture of a bone, cartilage, or tooth, or dislocation, or subluxation of a bone, joint, or tooth. So we say someone hits a person, and as a result of the assault, or result of the act, a bone is broken, a tooth is broken. That is then similarly permanent privation or impairment of the hearing of either ear. So you slap a person, it might be heard, but you slap a person so hard that that person's hearing suffers permanently. That would be grievous. And so on. Then there is another aspect which says any injury which endangers life, or in consequence of which an operation involving the opening of the thoracic, abdominal, or cranial cavities is performed. Because of injury, as a result of an operation has to be done, opening up the head, the chest cavity or the stomach cavity, then again that is grievous. Then if you cause severe bodily pain, so that he is not able to follow his or her ordinary pursuits for a period of 20 days, or because of an injury, so for 20 days he cannot engage in his regular pursuits, then also it becomes grievous hurt. So grievous hurt is the most serious, it's an aggravated offense of hurt.
Yes, sir. So could you explain what an alibi is and how important it is in a murder trial?
Well, an alibi is what an alibi is when a person says, I was not there at the I was not there at the scene of crime. In Sinhala, it's called Anyasthanagata veema. So you basically say you were not there, you were elsewhere at that time. So that is a defense which an accused can take and say, this is not, I was not there. Though witnesses say I did it, I was not there, I was elsewhere. Now, what is interesting is you don't have to prove your alibi. The law says that you don't have to prove an alibi. What you can do, what you do is to cast a doubt. To cast a doubt in the minds of, you can cast a doubt in the minds of the judge or jury. And if the judge believes your alibi, if you are accused and you say you were elsewhere, if the judge believes you, the judge has to acquit you. If the judge doesn't believe you, still the prosecution has to rely on its evidence. But if the judge or the jury neither believes nor disbelieves, that means still there is a doubt. So then again, the accused is entitled to be acquitted. But as of from 2006, there was an amendment to the Criminal Procedure Code. So if you take up a defense of alibi, you must take it up early. So either in your police statement, when you give as a suspect, you give a statement to the police, or at least when in the course of the trial, when the trial starts, either in the non-summary or at the trial, before the trial starts, you have to say, give a notice of alibi and say you are going to take up that defense. The alibi basically means that you were elsewhere at that time.
So how does the
But again,
law look at...
sorry, I must clarify this.
Yes,
This
sir.
is that is you must alibi means you have that basically it excludes the possibility of the person being able to commit the crime. So it is if you were in the adjoining house, or if you were if there was a possibility that you could have come to that where the offense happened, that might not be an alibi in that way. But then if you say, we say at that particular time the offense was in Colombo, but you were in Colombo, but you were elsewhere. You were having dinner with someone. You were at such and such a place. Then that might discount the possibility. That discounts the possibility of you being the perpetrator.
Okay, so so how does the law look at a situation where a child or a teenager commits murder, and in the event an adult uses a child to, for example, say pour poison in somebody else's food, in such a situation, how will the accountability be held towards the adult, and is there any accountability on the child?
Well, the children, there is in respect of children, there is a statutory limit that if a child of a particular age, earlier it was 8, I believe now it has changed. Then in that event, if a child is if the child is less than the statutory age limit, then there is no liability. Then there is between a particular ages, again, if by reason of immaturity, if child is unable to comprehend the consequences of his action, again, he there is a possibility that he can be acquitted. But a particular age, below a particular age, then there is no likelihood, then there is no offense. In respect of, but of course, this is not children who are above a particular age, above 12 years, between 12 to 18, you are fully liable. But a child, in respect of murder, child cannot be sentenced to death. If a child will not be subject to the death sentence. Of course, there is an argument there whether it is at the time of conviction, whether that age limit is at the time of conviction or at the time the offense was committed. There is a debate about that. There are certain judgments which say no, it is at the time the offense was committed. You look at the child's age. So that is that is the answer to that question. But where children, where an adult uses a child, the adult will be liable for that offense.
And not the child, sir.
Not the child.
And the adult will be liable for murder and the relevant punishment.
Yeah, so for instance, an adult gets a 6-year-old to go and put poison into someone's coffee. The adult will be liable for the offense of murder.
Okay, so can you explain what genocide is, and do we have laws pertaining to genocide in our country, and also the international perspective on genocide?
Well, genocide is it's an international crime, and this is where those are acts, including killing, which are done to destroy a particular group, a racial, ethnic group, so on. And well, we don't have a law. Those are not part of our law in the sense we don't have laws making genocide a crime. But certainly those are international crimes. But in fact, the International Criminal Code, there are certain offences which are what are called international crime, which is the jurisdiction of that code. So genocide is the most serious of those crimes. Then you have genocide, crimes against humanity, and war crimes. And there is also the crime of aggression, which is set out in the statutes of Rome, but it has never been really defined. So those are the 4 crimes which the ICC, International Criminal Court, has jurisdiction.
Thank you, sir. We have come to the conclusion of the main discussion. But prior to this discussion, we sent out Google Forms and we asked the general public to send us questions. And some of the questions are, Can a convict of murder pardoned?
Can
a convict of murder be pardoned?
I suppose it means that can a convict of murder be pardoned? Yes, the head of state of the country has the power to pardon any person who is convicted of any offense. So it can be any offense. The head of state, once a person is convicted, the head of state has the power to pardon. Of course, there is an argument to say that now even the head of state, whatever his powers are, there is nothing called untrammeled powers. There is nothing called uncontrolled powers. Every power has to be exercised reasonably and rationally, and after taking into account everything which ought to be considered. So, in that sense, even the head of state's powers to pardon will be subject to the fundamental rights jurisdiction of the Supreme Court. And if any unreasonable exercise of that power to pardon would be subject to judicial review. But certainly the head of state has the power to pardon, and that is not only in Sri Lanka, all over the world. The heads that is called the prerogative of mercy or power of mercy, that there are certain cases where even if in law it is an offense, there are other circumstances which justify a pardon. Now, in certain countries, in Europe, for instance, such as UK, there is a royal pardons board which would study the matter and recommend to the head of state to issue a pardon. And pardons are not issued as a matter of course. But in other countries, this power is there. So you have the American presidents. They exercise the powers of pardon, and there have been various instances where the powers have been exercised.
There's another question, sir. We have seen sometimes accused of murder are being acquitted when media is showing clear evidence that they committed the murder. What happens within courts?
So, one thing, the center of that question, you must understand that what the media says is not evidence, right? And you might listen to the media and decide to convict a person, but the person has to be convicted on evidence laid before a court of law. Judges don't watch TV and take decisions. They don't look at Facebook and take decisions. That would be very dangerous. If you are at the receiving end, if you are accused, and the media can sensationalize, social media can decide to hang you. But that is not how the law operates. The law operates on evidence laid before a court of law. And in that evidence, the court has to be satisfied, and the threshold is beyond reasonable doubt. Proof beyond reasonable doubt. And over history, the people are convicted by the media. People are found guilty by the newspapers. But that does not mean the courts of law find them guilty. That has to be evidence based according to law and satisfy the threshold of being proved beyond reasonable doubt.
The next question, sir. If a bystander witnesses a murder, is it compulsory that he should provide evidence to court? If he doesn't, is it a crime?
As I told you, under the Prevention of Terrorism Act, it is a crime, failure to give information. Well, in here we don't have that offense of failure to give information. But if the police can require you to be present and to give a statement, the Criminal Procedure Code, you can be called by the police to give a statement, then you would have to disclose truthfully what you saw. But there's nothing to say that you have to voluntarily go and give information to the police. Of course, you have a moral duty, certainly you have a moral duty, but in law, if the police summon you to give a statement, then you have to truthfully say what you did see.
The final question, sir. Can damages be claimed in a murder case by the family of the victim? Do they have to go for a civil case?
Yeah, in murder, or if a person is convicted of murder, the sentence is the death sentence, and there is no question of a further fine or compensation. But if it is culpable homicide not amounting to murder, then it is possible that the court can order orders under the Victim and Witness Protection Act. Also, there can be certain compensation ordered, but there is a threshold, there is a maximum limit of the amount which can be awarded. And if you do want real damages, you have to file action in the civil courts.
Thank you, sir. We've come to the end of the discussion. We'll move on to the vote of thanks.
Thank you.
Thank you, Zeenath. So first, I would like to thank you, our Honorable Speaker, President of the Bar Association of Sri Lanka, and President Counsel, Mr. Saliya Peris, for sparing time of his very busy schedule to educate the public and us on this very important topic. And we hope it was a very fruitful session for the general public as well. And then I would like to thank our participants for being very active and sending us questions and being here with us throughout the whole session. Finally, I would like to thank Nirmal Pereira from our media committee for handling all the tech stuff, creating this whole project very productive. So thank you all. Have a good night.